Attorney Matt Thomas and Attorney Patrick Grody here again today to talk about some issues in criminal law. Matt, how you doing?
Hey, good afternoon, Patrick.
Hey, and before we get started on today's topic, which is going to be the Stored Communications Act and some notices that we're seeing our clients get more often, always remember rule number one, which is keep your mouth shut, no statements to anyone, no text messages, no posting on social media. And Matt, you know this, pretty easy answer. If you get a call from like someone who's an alleged victim, what do you think is going on right there?
Oh, that's going to be a control call for sure. So you should probably hang up the phone and call one of us.
That's right, because law enforcement is probably recording you, and it probably goes to the same for text messages. And then also make sure you never consent to any searches, whether it's for your car, your house, your computer, your cell phone, your DNA, and so forth. You have the absolute right to always refuse under the Constitution of the United States and exercise that right. All right, let's talk about the Stored Communications Act. And really, Matt and I'm going to share my screen. Now, Matt, you and I have seen this a couple times in the last few weeks, right?
Yeah, we have. And I mean, this is something that keeps coming up more and more and more, especially as law enforcement has kind of gotten a little bit more comfortable on how to utilize this in their investigations.
And can you just tell our viewers basically, how our clients are getting this? How are they receiving this message? And this one's from Apple, but I've seen it from Google, and I've seen it from Microsoft also. But how are they getting this message from Apple? Because this is very common for iPhone users, iPad users.
So basically what this is just a notice that law enforcement, or not law enforcement, but the provider is giving the client, saying that law enforcement has contacted Apple or Microsoft or whomever and trying to get information off of their cloud device. And this is commonly being done by law enforcement agencies across all service branches, because guess what? Our lives are on our phones. So messages, pictures, call logs, all sorts of stuff is going to be on that cloud storage device. And here in particular, it was a user that had an Apple iPhone device that they had been backing up certain information on their cloud, and law enforcement knew that. So they went out and they tried to get our clients' information, and luckily they contacted us and we were able to walk them on target on what they needed to do.
Yeah, and I mean, this one's from the U.S. Naval Criminal Investigative Service, NCIS, right? So NCIS here with this client went out and got their iCloud, and that iCloud, as you said, can have everything that a user has on their phone. And I guess, Matt, it depends, on the type of case as to what NCIS may be looking for, right?
Well, yes and no. So if it's a case that specifically involves pictures or videos, and we are seeing a lot of that all up and down the East Coast, where people are taking pictures or videos of something that they probably shouldn't, so that the law enforcement agents, they automatically target, these types of devices where these things can be stored. But no matter what you're being investigated for, law enforcement knows that communications, text messages, or even social media chats are going to be stored sometimes on these cloud devices, and they can get that information. So they can get facts and circumstances and information about everything that they're trying to investigate on our clients.
And I think it's also, we bring this up right now, when a client gets this, there's not a lot of legal recourse they can take immediately to stop this from happening, right? I mean, Apple's complying with a lawful search warrant or some type of authorization, right?
So there's nothing that the client can do themselves, but they got to reach out to us, and they got to let us know this, because what we can do is we can start doing the research and the legwork on the front end. So when it comes time to take this to trial and to get that motion to suppress teed up, we're ready and we're good to go. And we get the jump on law enforcement and the prosecutors on this all the time. I'm working on a case right now where this is an issue, and they're not tracking it, but I am, because my client told me from the get-go, hey, they did this.
And I think, you're onto something, is that this is pretty serious. I mean, if they're going to the extent to pull, your iCloud account from Apple and then spend the time to go through it, they are vested. I mean, they are invested in your case. I mean, they are investigating you. They are trying to build a criminal case against you. And I don't care if it's the military or it's the FBI or the ATF or state and local law enforcement. If they're putting the time in to get this information, to go to a judge, to get a search warrant, to go to Apple or Google and get your cloud and go through it, they mean business, right? I mean, this is not just going to go away. They think they have a case and they're putting the effort into it. This is already past the, hey, there's nothing going on here test.
That's 100% right. When we see all these steps being taken by the prosecutor, by the command, by law enforcement, the more that they have invested, the more time, the more resources, the more manpower that they put in, the more likely that you are headed to somewhere where you don't want to be, and that you want somebody who's been there before. So if you find that you're getting this message, you need to reach out and contact somebody like Patrick or myself who can guide you through this process, because 100% right, they mean business and they're coming for you.
All right, let's just walk our viewers quickly through how this works under the law. I'll be quick. What I'm showing you now is what's called the Stored Wiring and Electronic Communications and Transactional Records Access, Chapter 121 to the United States Code. That's federal law. And what this does is this is a law that was enacted that governs how internet providers and email providers and cell phone providers can actually turn over content. And content is different than simply records. Records would be like, when did you last access your email and from what IP address? Content would actually be, what does that email say? What is the substance of that email? What is the content of your pictures? And so that's really what the communications part of it is, and what that's focused on. And for our military people, I want to point out something that is sort of interesting, because it's new, and I'm going to do some fast searching here, but it used to be the military courts couldn't get this stuff because they didn't have the power to issue search warrants. And then the Stored Communications Act was amended to actually include in the case of a court-martial or proceeding under Chapter 47 of Title 10, which is the Uniform Code of Military Justice, issued under Section 846 of that title. And Section 846 is actually Article 46 of the UCMJ, which actually is the legal authority for search warrants. So that is how, especially the one we looked at earlier, that NCIS, in the case of a military member, can go to a military judge with the trial counsel and ask for a search warrant under Article 46 of the UCMJ and go out and get your content. And they can go out and get your content. Now, the other thing that's interesting in the statute and the Stored Communications Act is this notice requirement. So if you look at the notice requirement, there is really no requirement that the provider notice the subscriber or customer. With a search warrant, they're not required to notice them. However, they can give them notice except under certain circumstances, and that's down here where it talks about delayed notice under Section 2705 of this title. And what's under 2705 is it says that they can seek delayed notice where the court grants an order delaying notification under 2703B of this title for a period not to exceed 90 days. So if the court determines that the criteria are met, then essentially you would get delayed notice 90 days after they actually got your cloud. I am told from some friends that are lawyers for these companies, these tech companies, that they generally provide the notice like the one we saw immediately after they turn over the cloud to law enforcement. And the reason they don't do it beforehand, obviously, is that the customer or subscriber could go in and delete stuff. And so they wait until right after and provide the notice. And obviously, if there's delayed notice, then you may not be getting notice until 90 days after they've turned it over. So, Stored Communications Act, we talked about. So we talked about the legal basis to how they're getting this. We talked about why they're getting it. Let's get in maybe a little more as to what you can do about it. And Matt, you talked about a motion to suppress. And what I'm seeing in my practice, and I see it across state, federal, and military, is that law enforcement today, because of the amount of data they can access in a cell phone, whether it's they're hooking it up and they're doing a forensic extraction, or they're going out to get an iCloud or a Google Drive or Gmail, whatever it may be, they are essentially going on fishing expeditions and looking through everything known to man. And I got a war story to tell you about a child porn case that I did a year ago. But right? I mean, these are total fishing expeditions by law enforcement, aren't they? In many ways.
Oh my gosh, they have just taken this and they've run wild with it, and they're using it as this just broadcasting of a net to try to get as much content and data that they can. And a lot of the time, these issues are ripe for a motion to suppress, and that it should be taken in front of a judge and say, "Hey, judge, yeah, I get they tried, but they tried really bad, and they didn't, take the right steps and procedures to make sure that they were following the guidelines that have been set out to get this content. And when they don't follow the rules, they get slapped. And a lot of the times that the judge, as long as that judge has the fortitude to do it, he will suppress that content."
Right, because a search warrant has to be based on a probable cause that, one, a crime has been committed. And, that's a very easy hurdle to get over, right? That's not a hard hurdle generally for law enforcement. But the second part of it is that the place to be searched will yield evidence of that crime, and they have to be very particular about what they believe the evidence that they're going to find in that place or on that person is going to be. And then a search based on a search warrant is supposed to be narrowly tailored to find that evidence that they've articulated. And let me give you my war story now, right? Is I had a client, he was a sailor, and he goes into NCIS and he tells NCIS, hey, he was accused of sexual assault. He waived his rights and talked to him, this is sort of one of the reasons why you never do it, right? But he did it, and he kept saying, like, I'm innocent, I didn't do this, right? And so, and he kept saying, I have text messages between me and the girl afterwards. Everything was fine. We were talking about it. This wasn't sexual assault. And so what did NCIS do? They went and got a search warrant for his cell phone. Why? Because they want to get those text messages, okay? And the search warrant is very specific that, hey, we want to get text messages from this number and this number, which is the two numbers of my client and the female that had accused him of sexual assault. So what do? They go and they use Gray Key, right? What is Gray Key? Gray Key is the latest and greatest extraction software for Apple. It can break Apple's encryption, and they download everything. But what do they look at in addition to the two text messages? They look at every picture on his phone, and even pictures that are not in his Photos app, pictures that were there because of his web searching history. And what did they see? They saw thumbnails, right? Very small, low quality photos of what they believed to be child pornography. And guess what, Matt? He wasn't charged with sexual assault. He was charged with possession of child pornography. But what happened? We took it to an Article 32. And, I convinced the investigating officer there of two things. One, the government couldn't proceed to trial because I was going to be able to suppress that evidence. And then two, we're talking about thumbnails. And so the investigating officer in her report found that there was issues with not only probable cause, because I had raised whether he had knowingly possessed these things because they were thumbnails, but she also brought out the exact case I cited regarding the scope of the search authorization and how it was an illegal search, that we were only talking about thumbnails. And so what did the commander do who ordered the 32? Not only did he not forward the case for trial, but he actually dismissed the charges and took no administrative action against the sailor. So great result because of the legal issues involved. That sailor went on with his career and he's doing great. But I guess there's some points to make in there. Number one, maybe if he didn't talk to NCIS, he wouldn't be in that predicament. You don't know. But two, there are a lot of legal issues with what law enforcement is doing with cell phones and with search warrants to try and get cloud-based data. And there's a lot of it out there.
Well, one of the best things about that story is it just goes to show that when you get somebody in there early and they're able to look at that, see the issues and identify them. Patrick, you were able to come in and kind of shape the battle space for that case from Jump Street, whether it be at the Article 32, made sure that those recommendations benefited that client and then got them a great result. And I mean, that's just one issue that we're seeing. We're also seeing a lot of temporal issues where, the law enforcement will say, hey, I need the content from this amount of space, from one day to another day. But then they cast their net to years past. And, that opens up their aperture to get everything that under the sun, which may not be applicable. That's just another issue that we see a whole bunch of. But I think the main takeaway from your story is the benefit of you coming on that case and that client having an open dialogue with you to let you know what some of those issues were. And he was able to get a fantastic result. And that's fantastic.
And it's funny, Matt, because he first called me and it was a sexual assault case.
Yeah.
As we started talking about it more and I spoke to the prosecutor early on, I knew there was something else going on. And I figured that out and started doing the legal research and we figured it out. Got a great result for that. So Matt, any parting words on what we've been talking about today with the iCloud and search warrants and the Stored Communications Act?
No, just call early, call often. And if anybody asks you any questions, especially law enforcement, about your case, you know what to do.
That's
Shut
right,
up. Matt. Don't make a statement.
That's right. All right. I'm Patrick Crody from Crody Law in Jacksonville, Florida, 904-383-7261. That's attorney Matt Thomas, Jacksonville, North Carolina. Matt, give a shout out and your phone number.
You can contact me at 910-939-0263. And I help out everybody across the East Coast, especially in North Carolina.
All right. Thanks, Matt.
See you, Patrick.